Hi there, this is Jonathan Ginsberg, and today I'd like to talk to you about how I approach a case where the primary impairment is back pain. As you might expect, Social Security judges see a lot of back pain cases. It's probably the most common physical ailment that Social Security judges are going to see. And as such, you really need to keep in mind that you've got to stand out a little bit, because again, a lot of people come in with osteoarthritis and pain in their back, lower back, and again, because judges see it so often, they tend to sometimes discount the severity of it and whether it in fact is truly disabling. Further, you have to realize, and this is something you probably wouldn't think about, but it's actually the case, some of the judges that I've been in front of have actually had back surgery, because again, back problems are pretty common in the population. And of course, a lot of these judges have very good insurance, they have physical therapy afterwards, they have good doctors and so forth, and so their recovery might be more uneventful than yours. Again, a judge is not doing physical labor, and again, it's got typically really good health care. If you've done physical labor, if your health care is not as good, you don't have access to physical therapy or medication or as much follow-up, then you may not have gotten the same results as the judge. But again, the judge who's deciding your case is looking at you saying, well, I went through the same surgery and I'm fine. Yeah, I can't play basketball anymore, but I can play golf and I can do a lot of different things, and you know, he or she, you know, may feel like, well, you know, I've recovered, why can't you? And again, that's just human nature, but just be aware of it. I'm not saying that makes the judge not sympathetic to you, but just be aware that you need to do something to stand out a little bit and show the judge that your situation is one that did not resolve as easily as his or hers may have. I think that when you're dealing with back pain cases, like in any Social Security case, number one, you want to emphasize if you've got a long work history. I think this is a factor that you may not think about again, but this is, I think that many judges find it very, very compelling. If you have a long, consistent work history where you've been at a job, you performed admirably at the job, you've made good money at the job, people don't give up good jobs and an opportunity for retirement, pleasant retirement and so forth, to collect, you know, $1,500 or $2,000 from Social Security. So if you've got a long work history, especially if it's been with one company, emphasize that. Let the judge know that you're not leaving your job because you want to retire, but because you have really no other choice. By the same token, also explain to the judge that you tried to look for a job that was less damaging or demanding on your back. You know, I think in back pain cases, unsuccessful work attempts, and that would be defined as a job attempt that lasted less than 3 months. That can be very persuasive. If you show that you went to 2 or 3 different places, tried to do different types of jobs, maybe job 1 there was too much standing, job 2 there was too much sitting, whatever, but you show you've really tried to work but that you could not find anything that would fit your particular profile and your capabilities, judges find that compelling. Be aware, of course, that once you get beyond 3 months, it looks like a real work attempt, and that can be a problem. So, and I've discussed this in another video, which I'll have the link here on screen. But be careful about work attempts that last longer than 3 months. That can be an issue. But if it's less than 3 months, even multiple unsuccessful work attempts can be fairly compelling evidence. I think with back pain cases, you need to be prepared to show diagnostic studies, ideally an MRI that shows a herniated discs or multiple herniated discs. CT scans can also do it. Realize there's a difference between a bulging disc and a herniated disc. A bulge is not as serious, and a lot of people walk around with bulging discs without problems and they're able to function, whereas a herniated disc is something that's a little more serious, takes longer to recover from. So ideally, judges are looking for herniations, although bulges at multiple levels, especially if the bulge impinges upon your spinal cord, that can also be helpful. But again, judges are going to look for diagnostic tests. X-rays are not going to do it. It's going to really need to be an MRI or CT, and of course I know those are expensive and sometimes it's hard to get them, but if you don't have them, that's going to make your battle a little bit more uphill. So I think, again, ideally you should have diagnostic tests, and also to that same point, realize that disc problems can heal. So if you have an MRI from 4 years ago, a judge isn't necessarily going to believe that your back condition is exactly the same now. So again, if you can get repeat MRIs showing that the herniation is still there, you're still having problems, or it's gotten worse, that can be helpful. And I think, just as you want to show that you tried to work, if you've got back problems, show that you've been completely compliant with your doctor's proposed therapy, whatever it may be. If the doctor tells you to lose weight, try it. Even if you're not successful, that if you try it and show that you made a good faith effort to do so. Sometimes it's hard to lose weight, either A, because you're not mobile, or B, maybe you're diabetic or there's other issues, but show that you gave it a try. If you smoke, you should stop smoking, because again, as you may know, a lot of doctors will not do surgery on people who smoke, and again, that just shows you're making an effort to try to improve your situation. Judges appreciate that somebody who has a health problem is doing everything he or she can to improve that situation, even if it's not directly related to the back problem. It could be to your general health, and again, losing weight and stopping smoking could be two of those factors. I think you should be completely compliant with treatment, and just my experience has been that when somebody has a back problem, typically the doctor will start out by offering some form of physical therapy to try to strengthen the muscles surrounding the back and so forth. That may not always work, but again, that's typically the first part of what they call conservative treatment. Secondly, they may suggest epidural steroid injections or blocks, and these are different types of they're minimally invasive treatments where they inject your back, or they do a radio frequency to kill off nerves, and these are things that are short of surgery but can provide relief, sometimes long-term relief, and if doctor recommends that and you go through it and still are not having any success, again, that shows you're trying your best. And these things can be painful, by the way, so again, a judge will recognize that if you're not able to get relief from these things but you're trying it, that's showing some good faith. Typically, after that, surgery would be the next option if you're a surgical candidate, and of course, not every back problem is a surgery candidate. And by the way, judges do not hold it against you, or they shouldn't hold it against you, if you decide not to undergo surgery. They recognize that back surgery is pretty major surgery, it's pretty invasive, and if you choose not to go that route, a judge is not supposed to, in my experiences, they won't hold it against you, especially if you can explain why you didn't have surgery and be prepared to answer why. A lot of times it's because my doctor said that there's a possibility I could be paralyzed, or this won't improve my pain, or my situation won't get any better. That would be a reason why one would not have surgery. So again, be prepared to answer that question, but that's the issue there. If surgery is not an option, or if it is an option, it's not successful, the next step in the process is something called long-term pain management, and that's usually where you'll have a doctor prescribe, and a lot of orthopedic practices have this. They'll prescribe narcotic pain medications to let you somehow live with some comfort. And of course, the risk there is that you get addicted to the pain medication, or that you have side effects. Obviously, drowsiness is a big problem. Constipation, believe it or not, is a big problem. Things like that. But again, if you're on long-term pain management, if somebody's coming in, they're on methadone, or they're on some sort of a hydrocodone, judges recognize that those can have long-term effects. And again, you want to emphasize that you don't want to be on these pain medications, but it does allow you to function in a minimal way. But that's kind of what judges are looking for. They're looking for extensive and ongoing treatment. It's not good if you haven't been to the doctor in 2 years and you're just getting pain medicine refills. You need to really try to get to the doctor. I think that a lot of people with long-term back problems also have a level of depression. I think this is especially true for men. If you're in chronic pain, it's not unusual to become depressed and to seek treatment, medications, or therapy for depression. That's something that's pretty consistent with long-term back problems. And I think finally, when you have back issues, you should be prepared to give very specific descriptions of your capabilities. Again, in a back pain case, the judge is going to know how long can you sit, how long can you stand, how much can you lift. And again, you want to be thinking in terms of very specific numbers. Avoid not very much or not very far. And if the judge says, for example, how long can you sit, a good answer would be I can sit for 10 to 15 minutes and I've got to stand up and walk around for 10 or 15 minutes to stretch out. I can do this 2 or 3 times. I can maybe sit for a total of 2 hours in the day, but after about 2 hours of sitting, even if I'm standing and moving around, my pain level gets to the point I've got to take a pain pill and I've got to go lie down. So be prepared to give totals, because again, if you can sit and stand and continue going back and forth, then there are jobs with what is called a sit-stand option that you could theoretically do. But if your total capacity for sitting is 3 hours in an 8-hour day and 2 hours standing in an 8-hour day, even with breaks, that's only 5 hours. That's not 8 hours, and that's not full-time work, and you win. So be prepared to give very specific examples of how long you can do various functions. I've literally seen judges take that testimony and plug it right into the question they give to the vocational witness, and of course the vocational witness is going to answer no jobs, and we win. So be prepared to be very specific, and remember, stay away from not very long, not very far, or it depends, and every day is different. You need to be able to give an answer, and it's very important to make sure that your answers are, and prepare with your attorney. If I'm representing you, we'll do it ahead of time, a week or two before the hearing. Make sure that what you're describing is not full-time work or not equivalent to full-time work, because you want to show that you're not able to do 8 hours of work during the course of a day. Generally, by the time you get to a hearing, most of the time these cases are decided on functional capacity. There is, of course, a listing for musculoskeletal. Musculoskeletal problems is listing 1. Very hard to meet the listing, and unless the medical evidence is really compelling and somebody at the state agency dropped the ball, it's not going to be listing level. So for the most part, you're going to argue functional capacity. You could argue the grid rules if you've got a limited education, limited work background, because again, if you have physical problems and a limited education and limited work background, some of the grid rules could apply. So take a look at those. Most of the hearings, though, I deal with are going to be functional capacity, where we're arguing that your capacity to perform reliably in even a simple entry-level job with a sit-stand option is not there because of limitations, physical limitations, as well as pain and the associated limitations that arise from the pain, i.e. problems of concentration, focus, reliability, and so forth. So that's how I approach back cases. And again, big picture is there's a lot of them out there. A lot of judges see them all the time. So you want to make sure that all your T's are crossed and I's are dotted. You've got compelling evidence so that you'll stand out a little bit from the crowd. I hope this has been helpful. Again, my name is Jonathan Ginsberg, a Social Security disability lawyer here in Atlanta. And if you have any questions, feel free to give me a call or drop me an email. Thank you very much.